Morning, Judge.
Good morning. How are y'all doing?
Good morning.
Well, why does this look different than it usually does? All right, I don't know what I did. Am I still there?
Yes, sir.
We can see you.
Well, the whole thing, here it is over here about the size of my thumb. What is that? I can't make this bigger. I don't know. It looks different. There we go. All right. Time is it? Is it 9:30?
Yes, sir.
We're not on the record yet. I'll let you know when we go on the record.
Thank you.
Did you just send me something, Jennifer, a few minutes ago?
Yes, sir.
A couple of somethings?
Yes, sir. Elizabeth Byers sent me the proposed disposition and I think the final order, and then Haley sent me the exhibits. So I forwarded you both of those emails.
Yes, I was trying to pull them up on my iPad here, and I was able to do that. I have both of them. My goodness, what is all? This is a bunch of stuff.
We have 13 exhibits.
Okay, yeah, it looks like it.
I mean, it's not a huge stack when you print it all out, but I mean, I was prepared to go forward with a contested, trial today. So.
Okay, looks like they all opened up. Looks like I have them here.
There's one file that it has all of them in a stack that are marked, and so you should be able to just refer to that one file. It should be the first one in the group.
Well, I've opened up an email here, and it looks like they're all one after the other. So it looks like I can see them. What is that? That's something else. That is. So you've marked all of these exhibits, and Haley has all of them?
Yes,
Okay.
I marked all of the paper exhibits. There's one recording that all of the hard copies and a removable flash drive with the recording on it has been delivered to Haley, hand delivered hard copies.
Okay.
And I can speak to, the fact that Ms. Harris isn't here yet. the first few pages of exhibits are e-filing notification receipts that show that she read everything that I sent her over the last several months. She opened all of the documents, even though she has represented to Jennifer that she didn't receive anything.
Jennifer, are you still there? Are you able to hear me?
Yes, sir.
Okay. Have we gone into the public domain yet?
Yes, sir.
Okay.
We're on YouTube. Yes, sir.
Okay. All right. That's fine. All right. I'm about to go on the record, and when I do, I'm going to address those number of emails that I received sometime yesterday afternoon. And what I would like to do, there's at least two of them that I want to email to you and email Miss Byer. And those that I emailed to you, I guess I'll email them to Haley too, and then you can print them off and mark them. Is that
Yes,
what we
sir.
would do?
Yes,
Okay.
sir.
All right. I don't even know if I've got your email address, Haley. Do I have it?
I don't think so because I don't have yours.
I can
You want me to
provide-
give it to you real quick? Or do you want me to
No.
write down yours and send you an email?
I'll provide you both with.
No, don't. I'm going to send it to Jen. I'm going to let Jennifer forward it to you.
Okay.
Let's do it that
Okay.
way.
Okay.
It makes that much difference. I imagine anybody that wants them can find them, but well, now I'm looking for something with a cause number. Here we go. All right, are y'all ready?
We're ready.
Miss Byer, are you ready?
Yes, sir.
All right. The court's on the record in cause number 09-13564 in the interest of CLT. The matter is set before the court today for a final disposition. The record will reflect that that the hearing is being conducted by video via Zoom, and it's being published over YouTube for any of the public who has any interest to attend can do so. It is the order of this court that this hearing not be recorded in any way. If anyone within the hearing of the court records this hearing or trial without the express permission of the court to do so, a formal record is being made, which is the official record of the court by the official court reporter of the court. Proceeding any further, the record will reflect that that Anna Tate, the mother of the child, is not present. It's the court's understanding that proper notice has been given to Miss Tate of this trial setting, and that she has, in fact, through communications with Miss Insinger, indicated that she is aware, communicated with her, correct? Jennifer, did you disappear? You're muted.
Yes, sir, that is correct.
All right. And the record will also reflect that commencing according to the time indicated on these emails, but commencing about 4:45 yesterday, the court received about 20 emails from Ms. Tate. And Ms. Insinger, did you receive all these emails or did you only receive a couple? What did you
No, sir,
receive?
I only received one email yesterday that was to Your Honor and I, just the one that was sent about, let me look to see exactly what time it was sent. Yesterday afternoon, it was about see exactly what time she sent that. It was at 4:10. It was titled Final Hearing, and it was sent to Terry Flanagan, Judge Flanagan, and myself.
Okay.
That's the only email I received.
And the email that's entitled Final Hearing was received by the court. That email is going to be sent to a copy to Ms. Byer and to Ms. Insinger. And when you get it, Ms. Insinger, if you would forward it so that the court reporter can have it marked, and it's going to be marked as an exhibit as Court 1 to the court reporter, which will be marked as Court 2. The other emails, I believe it's 18. They are entitled either notification of return service or notification of service or filing submitted or filing accepted or filing returned, all of which are clearly communications from the clerk's office to Ms. Tate. So it is assumed that the clerk's office would have these communications in the file, in the electronic file. So these are not going to be forwarded and marked and made a part of this record. With that, the email entitled Final Hearing is going to be forwarded
And Your Honor, I guess while you're doing that, I can just mention briefly that I wasn't copied on any of the communications yesterday, so I don't know what any of them contain.
It was assumed that you weren't. And that's the reason that they're going to be made a part of the record, since they were obviously an ex parte communication to the court. Y'all bear with me. All right, Ms. Insinger, the first one's been forwarded to you. You can forward it on to to our reporter, and she'll mark it as Court Exhibit 1.
Yes, sir. I just received it. Haley, I just sent that to you.
Okay. Okay. All right, I have it.
Did you receive it, Ms. Byer?
Yes, sir.
Okay.
All right, the second one's been sent, hopefully. All right, as to the remainder of the emails that were forwarded to the court, a couple of them were opened and viewed by the court, and it was determined that the tagline, which indicated that it was a filing, all of these appear to be from the clerk. So at the conclusion of this hearing, the court's going to delete these emails unless someone has any request to do otherwise. All of the other ones appear to have been, as stated previously, generated by the clerk's office. So they should all be in the file, in the electronic file.
Haley, I just sent you the second one. You should have it.
Yes, I have both of them, Court 1 and Court 2.
Okay. With that, Ms. Byer, are you ready to proceed?
Yes, sir.
All right, you may proceed.
Your Honor, I'd like to request that exhibits marked P1 through P13 be admitted into evidence.
All right, and all of these have been admitted. I'm sorry, have been marked.
Yes.
All right, the exhibits marked as P1 through P13 inclusive are admitted.
Thank you, Your Honor. Just so that it is on the record, procedurally speaking, exhibit P1 well, it starts with an email from Ms. Tate saying that she hasn't received notice of any of the hearings or proceedings. And then the following several pages are receipts from my e-filing provider that show that Ms. Harris opened and read every single thing that I sent her via e-file since September that this case has been pending, usually within an hour or two of me sending them. Every single one was opened the same day it was sent. So it's clear from this that she was absolutely monitoring the situation and chose not to appear at several hearings and chose to just pretend that this wasn't happening until she saw our third amended petition where we requested that she have no access permanently to the child, and she decided that she was going to do something at that point. I'd like to request that the court take judicial notice of the fact that Ms. Harris Tate, whatever her name is, did not appear at our status hearing that was in December, at our status hearing that was in November, and at our further temporary orders hearing that was in October.
It's so noted. And before you proceed further, just so that that the record is clear on these matters, the exhibit that was marked as Court 1, that is the exhibit, or that is the email, one of the emails that were sent to the court yesterday afternoon. And for the record, the email states, "Happy Wednesday. I won't be there tomorrow. I am not prepared. Not sure how anyone forced to be a pro se litigant could ever be successful. Every single filing I have filed in the last 2 weeks has not been accepted. I asked for a jury trial on the record. I've attempted to file several demands. I have emailed Jennifer. Thanks for all your help. Pretty sad that you take away a parent's ability to parent whom has always parented and wants to parent. Not once implemented any sort of restoration of a relationship that has been destroyed between mother and daughter for no factual reason except for what an alienated 10, 11-year-old tells you. One day, Cameron will realize what happened and will be a very angry, resentful teenager that was allowed to be turned against her mom. I will be there to pick up the pieces and work her through the trauma and try to get her not to hate her dad for doing it. Thanks, Anna Harris Tate."
And Your Honor, just to speak to the issue of Ms. Harris Tate's jury demand, this court informed her of the need to file a jury demand at our last hearing that she appeared at on September 15th. And also at that time set and noticed everyone in open court of the status hearing that we were to have on November 12th. And Ms. Harris knew that the issue of setting the final trial would potentially happen on that date. She, of course, again, has stated that she never received notice of any of these hearings, but she was notified in open court of that hearing for certain. And her jury demand, she has attempted to file a jury demand probably 4 times now. Her filings are rejected because she doesn't pay the $40 fee, but I will point out that she started filing jury demands as late as January 19th, which was about 3 weeks before today's trial setting, and would not be timely even if they had been filed properly with the clerk, as they hadn't been filed more than 30 days in advance of the trial, which is required by the rules of civil procedure.
All right, and as to the court exhibit 2, it states, "Not sure how I'm supposed to follow instructions from the DC when Jennifer won't set a hearing date." Any request for a hearing on any matters that have been made by Ms. Harris, communications were initiated by Ms. Ensinger to the court, and of course, Ms. Ensinger was told anything that she files or wants to set it on the, when we have dates that are set, and that the court would entertain any matter that she presented to the court. The record will also reflect that there was a hearing conducted by the court wherein Ms. Harris represented herself, and it was a several-hour hearing where she was afforded every opportunity to present any witness she wanted to present and to cross-examine witnesses, to make any arguments that she wanted to make. As to her request for a jury trial, had Ms. Harris chose to attend this hearing today rather than not attend the hearing, as she has chosen to not attend other hearings, had she attended the hearing and made a request for a continuance so that the case could be set on the jury trial docket, that request certainly would have been considered by the court. And if it had been properly presented, most likely would have been granted by the court. But she has not filed any motion for continuance requesting time to have the case set on the jury trial docket. She apparently has chosen to handle matters in a different way. Therefore, the court is going to go ahead and proceed with the trial today. Is there anything else, Ms. Meyer, that you would like to present to the court for consideration?
Yes, Your Honor, I'd like to have Mr. Tucker just testify briefly. Looks like my internet is a little iffy.
Well, you're coming through loud and clear here.
Okay, super.
All right, if you would, Mr. Tucker, raise your right hand to be sworn. Do you swear to tell the truth, so help you God?
Yes, sir.
All right, you can put your hand down. You may proceed.
Mr. Tucker, it's been since the middle of September since Cameron seen her mom and had any kind of in-person visit. How has she been doing?
Very well. My daughter is very happy. Her anxiety is pretty much none anymore. Her grades have improved in school. She's a completely different kid from what we've seen.
And when has she shown any anxiety or distress in the last few months when she's been with you?
Every now and then when her mom would text her, she would show some just worry from the text, but other than that, no.
And was she aware that we were going to attempt to finalize this case today?
She had an idea, yes.
And what did she tell you about that?
She was worried that she would have to go back to her mother's. And we just reassured her that we're doing what we can for her.
And have you had her visit with her therapist, Laura Wolf, to kind of discuss some of these fears that she's been having?
Yes.
And has Laura Wolf submitted an affidavit that's contained in the evidence now, talking about some of her feelings towards basically worries, anxieties, concerns about having to go see her mother?
Yes.
Has one of the things that Ms. Wolf reported that Cameron has stated she has a fear that if she's allowed to go back with her mother, that her mother will abduct her?
Yes.
Has Cameron indicated to you that one of the things that she is concerned and upset about with regard to her mother is that her mother seems to have a total disregard for following this court's orders?
Yes.
And is that substantiated to some extent by some of the evidence that we've produced that are that when she was ordered to have supervised visits and ordered to meet and exchange the child with you at a certain time, that she did not do that?
Correct.
So, for example, did she return the child almost 2 hours late from a visit after after she was ordered to have just a very brief unsupervised visit on that day?
Yes.
And did she also refuse to return the child at the ordered location and instead require you to come pick her up at someone's house once?
Yes.
Okay. Let's see. This case had been kicked off by a CPS investigation into Ms. Harris's disturbing behavior in front of the child. Can you talk about briefly what happened with that?
My daughter overheard her mother having phone sex with, I'm assuming, Taylor. I picked my daughter up from school. She was showing concern and worry. She had texted me a couple nights before after I had picked her up from school, stating that she was sad and angry. She did not tell me that night. When I did pick her up from school that week, she spelled out the words pussy and dick to me, and told me some of the language we heard of her mother saying, "You're my daddy, you're my daddy."
Did she also report to you that her mother told her that she better get used to it because she was going to be having lots of sex with Mr. Tate when he got out of prison?
Yes.
And was it your understanding that the person that she was talking about is a gentleman named Taylor Tate, who's currently imprisoned at Huntsville for intoxication manslaughter?
Yes.
And did Cameron report to you at one point that she had been taken to visit Mr. Tate in prison by Ms. Harris,
Yes.
like on multiple occasions?
Multiple occasions.
Okay, and so is one of the other concerns that you have the very unstable living situation that Ms. Harris has currently?
Yes.
What's your understanding of where she's living at the moment?
Victoria, Texas.
And how is it that you know that she's living in Victoria?
She's sent Cameron a message saying she moved far, far away, and we have seen records of her saying she moved to the area and she's looking for a job in the area.
Okay. And to your knowledge, has Ms. Harris been evicted from like at least 3 or 4 residences over the last 2 years?
Yes.
I mean, how many places has she actually lived? How many different places since our last final order in this case?
Our last final order.
One moment. One moment. Haley, did you get that? All of a sudden, my screen locked up for about 2 seconds.
Yes, sir, I did get it.
Okay.
Yeah, I didn't have a cutout. Do you want me to, I don't know what the last thing you heard was.
I think I caught everything, but I mean, it just went out I missed 2 or 3 words. I understand the meaning.
Okay.
I just wanted to make sure you got it.
Okay, yes, sir. I didn't get a cutout on my end, but
Okay,
thank
very
you.
good.
Thank you for double checking with me. I really appreciate that.
Okay, all right. Well, you may continue, Ms. Byer. Go ahead and ask your next question, if you will.
Thank you, Judge. I was just asking Mr. Tucker what, to his recollection, how many different places Ms. Harris has lived in the past two years since their prior final order had been entered.
She lived in 5 different places.
Okay. And we know that she's been evicted from at least 2 or 3 from looking at public record filings of evictions and also from hearing Ms. Harris's mother testify at one of our prior hearings, correct?
Correct.
Okay. Lastly, is one of your major concerns with Ms. Harris the way that she interacts with Cameron when they do talk?
Yes.
And can you articulate a little bit what the problem is? One of Ms. Harris's issues is and has been in the most recent past in this case.
She uses language 11-year-old shouldn't hear. She talks to her as if she's an adult. Uses terms and phrases that a 11-year-old should not hear.
Does she have a tendency to try to cross-examine the child and interrogate her relentlessly about this litigation?
Yes.
Do we have, submitted a recording into evidence as an example of that? When did that recording take place? Do you recall?
September 16th, the day after our hearing, one of our hearings.
Right. So, and actually the last hearing that we had in this case that Ms. Harris appeared at was on September 15th, correct?
Correct.
And again, she was admonished by the court and everybody was that they were not to discuss this litigation with the child after that hearing. Is that correct?
Correct.
And so Ms. Harris actually had been admonished, actually everybody had been admonished not to discuss the litigation with the child and not to take her telephone away from her during visitations. Is that right?
Correct.
And was it your understanding that Ms. Harris totally disregarded those orders as well.
Correct.
And do you I guess, recall that the last in-person visit that Ms. Harris had with the child at Ms. Harris's home, the child felt that it was necessary to call 911 at that visit,
Yes.
and that she was exhibited signs of being extremely upset when she was returned to y'all the following Monday morning.
Yes.
Is there anything else that you feel like you need the court to hear at this point? Has Cameron asked, vehemently requested to be able to talk to the judge about this case if what the requested possession schedule was in question at all?
Yes, she did.
And Your Honor, we had filed a motion for the judge to confer with the child, and I'm assuming that that's probably not going to be necessary, but I did just want to point out that Cameron herself did want to express to the court her wishes, and she is almost 12 years old. So.
She is what? Say that again.
She's almost 12. She'll be 12 in November this year.
All right, the court finds at this point that it's not necessary for the court to interview the child.
Your Honor, I have submitted a proposed disposition of issues that has just a bullet point list of the things that we are asking for. And I've also submitted a detailed, complete final order that actually has check boxes for whether Ms. Harris appeared or not. And I just request that the court be able to sign the final order that we have submitted today.
Have you submitted a proposed judgment? Is that?
Yes.
Oh, okay. I see it. I see it here. I am unable to tell which page this is. I'm looking at this on my iPad, but after the paragraph after numbered paragraph 5. See that?
You cut out there for a second. The
Yeah,
paragraph.
the paragraph immediately following numbered paragraph 5 under the duties. It is ordered that at all times Landry Tucker and Anna Harris shall have the following duties. And then you've got each paragraph numbered.
Yes.
The paragraph that's right after numbered paragraph 5 that states it is ordered that. You see that?
Yes.
Do you want the word temporary in there?
No.
Okay.
You.
Okay, if the all relief requested by the petitioner is granted, the proposed judgment and decree will be signed by the court. If you would make that correction and forward the judgment.
Yes, sir. And I will send it in.
I'm sorry, go ahead.
I will send it in a PDF form so that it's signable.
Yes, if you just send it to Miss Insinger, she'll forward it to me, and when I get it, I will of course sign it and return it to Miss Insinger.
Yeah.
All right, and that should be accomplished sometime this afternoon, I would expect. Is there anything else that needs to be mentioned by anyone?
I don't think so. Good.
Or includes this trial? Say it again.
I said I don't think so, Judge. Your connection's cutting out a little bit.
Okay. Haley, do you feel like you've been able to make a record?
Yes, sir. Yeah, it just was like a little lag. You would cut out, but then it would catch itself up. So I think I got everything. Yes, sir.
Okay. All right. Ms. Insinger, you need to say anything else to me?
I think we got it all. Thank you.
All right. Okay, with that, that concludes this matter. As requested, just forward the judgment to Ms. Insinger and it'll be forwarded for signing. Okay, if there's nothing further, then I am going to click this little red button that says leave. Y'all all have a good day. Stay safe. All right.
Bye, Judge Flanagan.